Okay, I'm going to go ahead and launch right in. Thanks everybody for coming. I just turned the recording on just so that you know. And this recording, as well as the recording of part one, will be sent to you within the next day or two. So if you're joining us for the first time and you missed part one, that's perfectly okay. You do get a chance to make up for that. And I'll also be giving you PDFs of the slides so that you have them for future reference. So thank you to Anita Prouty from NFP, who some of you know because she's your account exec. She's here to help out and monitor the chat, but I'm really hoping that you're going to feel comfortable unmuting. I've set this up as a meeting so that you can do that. And this way we can maybe get some discussion going. It's a lot easier for me anyway than reading off of the chat, but certainly feel comfortable to type any kinds of questions into the chat as we go as well. So we do have a lot to get over today. I'm kind of going to pick up where I left off last time and dive into some other key legislations that are out there that you really should know about if you're in an HR role. And we'll talk a little bit more about some additional best practices that will lead to compliance with that legislation. And my standard disclaimer, I always need to let you know that I'm not giving any kind of legal advice or tax advice. HR does dive into that legal realm and that IRS payroll realm on a regular basis, but I can point you in the right direction, but nothing that I'm telling you can be legal or tax advice. So we're going to start off with the Fair Labor Standards Act, or the FLSA. And this is the legislation, it's a federal legislation that governs the overtime, meaning who's exempt, who's non-exempt, who gets paid a salary, who gets paid hourly, and it also governs your child labor laws. So I get a lot of questions on the exempt versus non-exempt, and how do we know whether to pay somebody a salary or whether to pay somebody an hourly rate? And the Department of Labor is really very specific as to the employees that you can actually pay a salary to. And the rationale behind this is that they want to make sure that as many employees out there as possible who work more than 40 hours a week are going to get overtime pay for that time that they work. And they therefore have limitations on who you can pay a salary to. So we're going to review what those limitations are. The employees, in order to be considered exempt, have to be paid a fixed salary, and that fixed salary has a minimum. It's $684 a week, which is really pretty low. It comes out to be like $36,000 and change. Some states, however, do have a higher minimum. I think most employees that are exempt and being paid a salary are well over that minimum, but if some of the nonprofits, that's not always the case. So if you have anybody that's out of state and is fairly close to that $684 a week minimum, make sure that you check the state to just make sure that you're compliant with the state minimum salary. And these people don't get paid overtime. So the idea is that they're not going to be paid on the hours that they work, rather they get paid for the job that they do. So they have a job that some weeks might take 50 hours to do, and some weeks might only take 35 hours to do. And it doesn't matter, they're going to get that same salary no matter what. Non-exempt employees, on the other hand, are paid hourly. And they are paid based on the number of hours that they work, and any hours over 40 in a given work week. It's not in a pay period, it's in a given work week. And that work week should be clearly defined in your employee handbook. So anybody who works over 40 hours in a work week is entitled to overtime, which is time and a half. And again, this determination is made by you, the employer, but it has to be based on these Department of Labor guidelines. So you can't just randomly say, you know what, it's a real hassle to monitor people's hours. I'm always chasing after them to input their hours into the system. I think I'll just pay them a salary. You can't do that unless they actually meet the definition of an exempt employee. And basically, there are these three tests. There's that salary test that we talked about. And bear in mind that if you have somebody who is working part-time, it can't be prorated. So you can't say, well, I have a part-time employee, and if they were full-time, they'd be making $45,000 a year, you have to take a look at what that is prorated. If they only work 3 days a week, you take a look at what would their full-time, what are you actually paying them for a salary? You can't say, well, this would equate to X amount over 40 hours. You have to actually look at how much you pay them and make sure that even if they're only working 2 or 3 days a week, they still have to be meeting that minimum of $684. And again, it has to be a fixed salary. So it's not something that you can say, well, this week we're just going to pay you a little bit less because you worked less. It's always going to be that same amount. And then you have the duties test. And this is where it gets a little bit gray. You've got different exemptions. You've got an executive exemption, meaning if you're a senior level executive, you have certain responsibilities, you can be paid a salary. The same thing for an administrative exemption. And that's the one that's really fuzzy and really gray, because an administrator, some administrators are really doing just pretty clerical work, and other administrators are really doing pretty high level work. So that one tends to be kind of gray. Your professional exemption is pretty cut and dry. Your teachers, computer professionals, certain computer professionals, your outside salespeople are generally considered exempt as well. So I could end up talking about this for a really long time, but if you are uncertain whether some of your salaried employees actually should be salaried, I would suggest getting on to the Department of Labor's FLSA Overtime Security Advisor. There's the website, and it gives you a lot of really, really good information, and it's actually will walk you through what this person's responsibilities are. And it'll ask you, do they do this? Do they make this type of decision? And if you answer yes, it brings you to the next question. If you answer no, it'll pop up and say this person is and should be paid on an hourly basis and should be getting overtime. If you're ever in doubt as to whether or not somebody should be exempt or non-exempt, my suggestion would be make them non-exempt and pay them on an hourly rate, because the Department of Labor is never going to complain about somebody who's really doing exempt level work, but they're being paid hourly, because they always want to see somebody getting their overtime. It's if it goes the other way, if you have somebody who's really doing non-exempt work, but you're paying them a salary, that's the one that can potentially get you into trouble. And the question I get too very often is, well, you know, how often does the Department of Labor come knocking on your door and actually ask about this? It happens, and it usually happens because there's been a complaint filed. You might have a disgruntled employee who thinks, I've been denied my right to overtime pay, and they go to the Department of Labor, and that will usually trigger the Department of Labor looking for more information. So it does happen. I can't say it happens a whole lot, but I've had clients a couple times a year say that they've got the Department of Labor asking them about their exempt employees, and they'll come and they'll ask you for job descriptions. And if they see that with this one particular individual that you might not be compliant, they're going to start digging deeper, and they're going to start asking for payroll records and job descriptions for more and more employees. So it really is important to stay on top of this one. Employment posters. Hopefully you all have them out there in your workplace. There are both federal posters and state posters. I know that some of you have asked to be put on Zywave since last week. Zywave is the online HR database, and I've gone ahead and given access to those of you who don't have it. If there's anybody out there who still doesn't have it, or you don't remember how to get there to sign on, let me know. I'll see that another welcome email gets generated. And there is a poster advisor that you can access through Zywave, or you can go directly to the state or the federal Department of Labor, and they will ask you questions about your business, and then they'll tell you these are the posters that you need. There are 3 federal posters. There's that EEO, Employment is the Law. There's an FMLA poster if you are over 50 employees, and the Employee Polygraph Protection Act poster, which is a standard federal poster. Those 3 need to be posted where your applicants can actually see them. So if you're posting them in a break room, unless you have applicants being interviewed in your break room, you're not going to be compliant on that. Those 3 posters, I would suggest putting them out in a waiting area or by a receptionist desk, somewhere where if you have somebody coming in for an in-person interview, that's going to be visible. When you have remote employees, which a lot of you do, you should be providing them their posters. So you can do that in a couple of different ways. You can email them to new employees, but I would absolutely suggest that you put them out there on your server somewhere and that you make your employees aware of where they can find them. And these posters do change from time to time. So I think some sort of a reminder to your employees, hey, by the way, remember your employment posters are here. Here's where you can find them. So you can either print them out from the federal and the state Department of Labor websites, or if you don't like the look of different pieces of paper hanging out on your break room wall, you can actually subscribe to a poster service. There are a lot of them out there. I'm just suggesting HR Direct or the Labor Law Center just because I know they're reputable. And a lot of them have additional subscription services so that they will give you updates anytime something has changed. They'll have some information on your organization, where you're located, the type of business you are, and if you ever need an update, they'll notify you. They'll either send you the additional poster or they might give you a whole new set of posters. It just depends on the type of service that you subscribe to. I think it's worth it because these posters do change from time to time. And sometimes, particularly if you're not a full-time HR person, it can get away from you. Any questions on employment posters or the exempt versus non-exempt? No? Okay, we'll move on then. Americans with Disabilities Act. This is nothing new. It's been around for quite some time, but it can be very confusing and it can get a little bit complicated when you have an employee who has an acknowledged disability and they're looking for an accommodation. So again, the ADA is for employers with 15 or more employees, but Vermont has its own law out there and that applies to all employers. And it's basically identical. So anybody out there who's on this call, you need to be following the stipulations of either the state or the federal. I'm just going to refer to it as the ADA just to make it simple. So, and it basically says that if you're an employer, you can't discriminate against anybody who is qualified to do the position because they have a particular disability. So people have to have an equal opportunity to apply for jobs. So that means you need to make sure that whatever method that you are requiring for people to apply, that it would be accessible to everybody. And that would be physically accessible. It would be accessible online works as well if you have people filling out online job applications. And from time to time, you may have somebody looking for some sort of an accommodation for that, and that's fine. Once they're there and they're employed with you, they have to have an equal opportunity to be promoted. They have to have the same benefits as everybody else has. You can't be denying somebody health benefits because you know that you're self-insured and they're going to cost you more money. That's pretty standard. And then there's that harassment clause that they can't be harassed because of their disability.
Susan?
Yep.
Before we get too much further, we have a question in the chat. They want to talk a little bit more about a non-exempt salaried employee.
A non-exempt salaried employee. Okay, that's possible. It's very rare. My suggestion would be the only time that you have a non-exempt employee who's getting a salary is if that person works a set number of hours and those hours don't vary. But that person still needs to be tracking their hours. And there is a calculation for paying them overtime if they go over 40 hours. So I'm going to take that one offline. If you want to reach whoever that question came from, if you want to reach out to me separately, I can give you that formula. And I don't know it off the top of my head, but it is a different way of calculating overtime. So I would say be very, very cautious about putting somebody on salary who is non-exempt, because you're still going to need to monitor their hours. And it can get a little bit trickier, especially if their hours do vary from week to week. So if you can reach out to me, send me a note, and I would be happy to go over that particular situation with you. Okay, so back to the ADA. You have to make a reasonable accommodation for someone with a disability unless it creates an undue hardship. And what's a reasonable accommodation? Well, the answer is, I'm going to sound like an attorney, it depends. What's reasonable is taken on a case-by-case basis. It takes into account different factors such as how large are you as an employer, how much money do you, what's your revenue, what type of a business are you running. So there are a lot of different things that come into play when you're figuring out, well, what's a reasonable accommodation. There is no checklist that you can look at and check off boxes and at the end say, okay, that's a reasonable accommodation or that's not a reasonable accommodation. And it's the same thing with an undue hardship. You know, if you are a very small business with a low revenue threshold, you may not be required to put an elevator into your building. But if you're one of the larger employers, if you're an IBM, yeah, absolutely, you should be required to put an elevator into your building. So again, it depends. And it's the kind of thing that has to be determined on a case-by-case basis. So your best practice here is if you have an employee who says, I'm going to have some difficulty doing this part of my job, that you sit down with that employee, you sit down with the employee's manager, and you start that interactive dialogue. And you talk to them about what are your essential functions of the position. And this is where a job description really comes into play. And we're going to touch on job descriptions in a little bit as well. And talk to them about, well, what kind of an accommodation do you think would work for you? And remember, you don't have to give the accommodation that the employee asks for. You just have to give one that's reasonable. And again, this could be a talk for about an hour. We're just scratching the surface here, but just bear in mind, the interactive dialogue is the really important piece that you talk to them, because I think that in most circumstances, both parties want to come to some sort of an agreement of how can we make this accommodation to make our workplace more accessible to you. And the employee is generally really going to appreciate that you're making your best effort. And in some cases, it can't be accommodated. If you really don't think it can be accommodated, I would totally suggest that you talk to an employment attorney, because they're going to be able to talk to you in great detail as far as your risk, some of the cases that they've seen out there, some of the legal determinations that have been made. So before you deny an accommodation to somebody, I would absolutely suggest that you seek legal counsel on that. Any questions about the ADA?
I've got a question, Susan.
Yeah, thank you for unmuting.
Yeah, it's easier than typing in the chat. I was curious around whether it's seasonal employees versus full-time year-round employees. Now that we have a lot of seasonal, thinking of those that may require interpretation services, which can be costly for a nonprofit. Do you have any resources or know of any requirements around seasonal versus full-time employment?
It shouldn't matter whether
Okay.
it's seasonal or whether it's full-time. You're required to make the same level of accommodation.
Okay.
So, and if you have any question, again, as far as how far should that accommodation go, I would talk to legal counsel about that. They can really help you out.
Okay.
Okay, good question.
Somebody asking about animals in the workplace. So I wonder if that's considered, under the ADA, Susan.
You know, that's a tricky one. And I'm not an expert on it, but there is a difference between a service animal and an emotional support animal. You are required to make an accommodation for service animals, but emotional support animals are viewed differently. So I don't want to get into a whole lot of detail on that one, but I would say do a little bit of research on the service versus the emotional support. You certainly can be requiring documentation. That's with any kind of a reasonable accommodation. You can ask for medical documentation regarding, what is the purpose of the animal? It's usually a dog. What's the purpose of the animal? Bear in mind that these animals that are service animals are really, really, really well trained. And I will give you an example. When I was in college, I had a blind student living on my floor, and she had a dog, and you would never in a million years know that that dog was even there. It was just there to support her. It wasn't a distraction. So if you're thinking in the back of your mind, oh, I just don't think we can have a dog in our workplace, it's going to be practically invisible. But again, there's a difference between service and emotional support. Hopefully that helps to at least get you started. Feel free to reach out if I don't have any actual resources. Again, legal counsel might be your best route if it's a really tricky situation. Any other ADA questions? Okay. So ERISA is something that we at NFP talk about a lot because we are a benefits broker. It sets the standards of compliance for your retirement and your welfare benefits plan. So I'm not going to get into the retirement end, but I will talk a little bit about your welfare benefits plans. As you know, your premiums can be taken from your employees on a pre-tax basis. And that's all part of ERISA. So ERISA is basically saying your employees don't have to pay taxes on the contributions that they're making to their health plan. But in return for that, we have certain standards that you need to be following as an employer. So that's why when you have your NFP account exec saying to you, you need plan documents, you need to send out these required notices, that's required under ERISA. We say that a lot. And what you're jeopardizing if you're not in compliance is your employee's ability to pay their premiums on a pre-tax basis. So ERISA really is important to comply with because everybody likes to take those premiums on a pre-tax basis. So the requirements for ERISA, and this is kind of in a nutshell, you are required to have summary plan descriptions. If you're self-insured, you are required to have a privacy compliance policy. There are a whole bunch of required notices. Those of you who have been here with working with NFP for any period of time know that usually in the fall, usually September, I partner up with Northeast Benefits Management, and we do a lengthy webinar regarding your required notices, your summary plan descriptions, what you need to be giving your employees during open enrollment, what you need to be giving them when they're new. If anybody is interested in taking a look at that, the benefits of doing things online is that it's recorded. I'd be happy to send you a copy of a recording or reach out to your account exec. They have access to the recording as well. And that might really help if you're a little bit up in the air as far as what those required notices are. It also says that your employees can only add or drop coverage in the middle of a year during a time that's not an open enrollment period for certain qualifying events. And that would be you've had a change in family status. So for example, somebody has gotten married, they'd like to add their spouse, that's fine. They can do that in the middle of the year. The change in the number of dependents, somebody has a baby, they can, or adopts a child, they can then enroll the child in the benefits plan without it being open enrollment. If your spouse is not on your plan because they're on their own health plan and they lose that health plan for some reason, not because they've just decided they don't want it anymore, but because they've somehow become ineligible, you can add your spouse to that plan. If you have a dependent who reaches age 26, then they will be dropped from the plan. You can't keep them on, although I believe, and Anita, correct me if I'm wrong, aren't there some coverages that will continue the coverage through the end of the calendar year that the employee dependent turns 26?
Yes, MVP goes to the end of the year, and Blue Cross and Blue Shield goes through the end of the month that the child turns 26.
Okay, thank you. So those are basically your qualifying events for adding and dropping coverage, and these are generally defined in a summary plan description. And ERISA also says that the plans can't be discriminatory. So this is where you're discriminate when we say, well, you need to be doing discrimination testing. This is where this comes into play. If you're ever questioned, you need to show that the plan does not discriminate against your lower paid employees. So in other words, you can't be top heavy with, well, our plan has all of our senior management team is on it, but very few of our frontline lower paid workers are on the plan. It has to be evenly distributed. So when we say you should be doing discrimination testing on your plan, that's usually done by a third party. Talk to your account exec if you're not doing that, because it might be something that you might want to implement. And I wanted to just make a note about the declaration of healthcare form. Hopefully that's something that all of your employees are filling out on an annual basis. If not, you can Google Vermont Declaration of Healthcare form and it will pop up. It's also referred to as an HC2 form. And that's the form that your employees fill out and they say, yes, I'm taking my employer's coverage, or no, I'm not, and here's why I'm not. And this form is used when you fill out your quarterly tax return. There's a question in the state return that asks about the number of people who are eligible for your plan, but they're not taking it. And you will get, if you're allowed up to 4 FTEs, full-time equivalents, of employees who are not taking your healthcare plan and they don't have coverage somewhere else. And if you have more than 4, you will get penalized on your tax return. So that's what the declaration of healthcare is for. And if you have somebody in the middle of the year that changes their coverage for some reason, they should be filling out a new declaration. Any ERISA questions? Okay, good. COBRA. This again is nothing new. Everybody is pretty much familiar with it. It's relevant for 20 or more employees, but Vermont again has their mini COBRA law. It's often referred to as a Viper, and that is applicable to all employers in Vermont. So even if you only have a health plan with 2 or 3 people on it, you are required to comply with the mini COBRA law. And they're really very comparable. And what that offers your employees is if they lose your healthcare coverage, whether they're terminated from employment, whether they have gone from full-time to part-time, so they no longer meet the eligibility requirements, they lose their coverage, then you are required to offer them a period of continuation for that coverage. And the coverage continuation is generally up to 18 months. We'll get into that in a minute. The qualifying events I just mentioned, it can be a voluntary or an involuntary termination unless it's gross misconduct. And gross misconduct is very, very narrowly defined. I mean, it's got to be pretty egregious, like somebody has embezzled money. It can't just be that somebody was insubordinate to their supervisor. That's not considered gross misconduct. If you really think that it is gross misconduct, I would consult with legal counsel as far as whether or not to offer COBRA. Your qualifying event for spouses. So if you have, if there is a spouse who has it, and I'm not that familiar with the Medicare rules, but it's a COBRA qualifying event if they become eligible for Medicare. It's a COBRA qualifying event if there's a divorce or a legal separation. Then you need to be offering COBRA to the former spouse. Obviously, if the covered employee passes away, then you would, and they had dependents on the plan, you would be offering COBRA to the dependents as well. You do have to offer COBRA for dependent children who have reached the age of 26. Voluntary or involuntary termination of the covered employee's employment for any reason other than gross misconduct. So in other words, if you have the employee whose coverage is ended for some reason, they've got family members on the plan, you need to be offering COBRA to the family members as well. And Each family member, it's best practice, should be getting their own COBRA notice as well. Now, a lot of employers actually outsource COBRA because it can get really, really complicated. And sometimes I get questions that I really can't answer because they're kind of tricky. They're not cut and dry. Everybody thinks, oh, well, it's a COBRA qualifying event because this person is no longer employed with us. It's not always that simple. Let me or your account exec know if you have any kind of a weird situation. We'll try to work through it with you. But these are the general reasons why you would be offering COBRA. And I did want to mention that even if you outsource it, you as the employer are ultimately responsible for COBRA compliance. So that means that if you have outsourced your COBRA to a third party, it's still going to be your responsibility to notify that third party that they need to be generating a COBRA notice. Somebody has left. That third party can also help you to figure out whether or not somebody is COBRA eligible. So that's another advantage of having a third party provider. But just remember that you still need to be notifying them because they don't have a crystal ball. They're not going to know that you've had an employee experience a qualifying event. You need to keep them in the loop and work really closely with them. And you need to stay on top of it. So COBRA is generally 18 months. In Vermont, it's limited to 18 months. You have to worry about anybody getting more than 18 months under Vermont's continuation law. But if you have 20 or more employees, there are a couple of instances where it gets extended out. There's an additional 11 months if you've got a qualified beneficiary who's disabled. In the event of a divorce or the death of an employee, it can go out as long as 36 months. The same thing when a child loses dependent status. But again, if you're fewer than 20 employees, it's 18 months tops. So what it really means for you is, this is the one thing that a lot of employers miss. There is an initial COBRA notification that needs to go out when somebody becomes eligible for your health plan. If you have a third party that you're partnering with, they may or may not be sending that notice. It depends on your agreement with them. If they are sending the notice for you, then you have to be diligent about notifying them that you have a newly eligible employee so that they can generate that notice. If they don't know, they're not going to know enough to generate the notice, and then you're not going to be compliant because it ultimately comes back to you. If they're not providing that, just bear in mind that this is something that should be part of your new hire process. If they're eligible for the health plan. It's up to you to be recognizing those qualifying events. So my recommendation is always train your supervisors on a very high level of HR, because say, for example, they have somebody coming to them and saying, wow, I'm really happy. Guess what? My divorce just went through, right? That supervisor should immediately say, oh, are you on our health plan? You should go talk to HR. They're not going to necessarily need to know all of the ins and outs of COBRA, but they should know that if they see that one of their employees is experiencing that qualifying event, they should send them over to HR just to make sure that HR is in the loop and is sending out the appropriate notifications. The notifications do need to be sent out within 30 days of the event, so there is a timeliness there. And the employee generally has 60 days to respond back, and then another 45 days to make that first payment. Now, I'm going to complicate things a little bit because there are some different rules in place with COVID. That 60-day deadline has been extended, and it's while we're in a state of emergency, a national state of emergency, which we still are. I'm not sure when that's due to expire, but the expiration date keeps getting extended out. If you have anybody who wants to enroll in COBRA and it's past that 60-day period, let us know. Let your account exec know, because they may still be eligible to enroll in COBRA. Chances are, if you don't hear from them in 60 days, you're not going to hear from them. They don't need to get back to you and specifically accept or deny COBRA. It's nice if they do, but very often you just never hear from them again. And that's okay. You don't need to be after them to actually get the response. But just know that if somebody wants to enroll after that 60 days, let us know, because it's one of those things that's kind of complicated. I don't know it off the top of my head until I'm working through a situation. So we'll work with you on that. The election notice, that's where you can find it. I always recommend that you go online and pull the notice directly from the DOL website, because it does change from time to time. And this way, you know that you're always using the most recent one. I've talked to employers who just keep it out there in a PDF form and they fill it out. And the form is 3 or 4 years old and it's changed since then. So I just would bookmark the website and go on and pull it right off of there. Also, bear in mind that you have to work through the entire form and it's pretty lengthy, but it's italicized where what you have to fill in. And there are spots on almost every page that you're going to have to fill something in. I've had employers fill out the first page and then never go beyond that and fill out the rest of it. So just a word of warning, make sure you're working through the whole form. Questions on COBRA? No? Okay. I-9s. Again, this is nothing new. This is the immigration form and the IDs that all new employees have to give you. You have to complete the I-9 form within 3 days of hire, and that's really critical. And the other piece that I would tell you is make sure you really fill out the whole form. And we're talking everything. The USCIS, which is immigration, will ding employers sometimes with fines for things like if they have a social security card as a form of ID, social security cards don't have an expiration date. Under expiration date, put NA. They get that picky sometimes, particularly if they're finding a lot of mistakes. So make sure that they're complete, make sure that all the dates are on there, make sure that they've all been signed. You can go online, and I apologize, I didn't give you the site here. If you want to do an audit of your I-9s, just type in Department of Labor I-9 audit, and there's a whole packet of instructions of how you can do an audit and how to appropriately make the corrections to any I-9s that aren't correct. So if you maybe are inheriting an HR situation and you think your I-9s aren't necessarily in compliance, it's a good idea to go in there and do an audit, but do it following the Department of Labor guidelines, because you can't use whiteout, you have to X things out, you have to attach notes. It's really, really specific. You can complete a 9-9 in advance, but one word of warning, it can only be sent to the prospective employee after an offer has been made and accepted. In other words, you can't send it out with a job application and say, here, fill out the I-9. And the reason behind that is it's going to give you information that you could use potentially for a discriminatory purpose. So only after an offer has been made and accepted can you give out that I-9 form. The original documents have to be examined. There are a couple of exceptions. I'll go through this in the next slide due to COVID, but this gets really tricky when you have a remote employee because they may not be coming into the office and you may have hired them and they live 2/3 of the way across the country and you may never meet them. But the USCIS says that original documents have to be examined. It's not okay to put them up on, to take a photocopy and send them, or to email a copy, or to put them up on Zoom and you can look at them through Zoom. They say that's not okay. I have no answer for you as far as how to handle remote employees that you're never going to meet, except to have somebody that is in that area act as your agent. So say, for example, you have a facility that's in another state. Have somebody at that facility be your designated I-9 person. For individuals, it's been really, really tricky. I don't know how to tell you to get the documents verified. I've had employers say, well, what if I get them notarized? What if they go to a bank and they have a notary do it? And apparently that's not okay. You have to find somebody who's willing to act as your agent. And that's really not what a notary is doing. Unless you can find somebody, you know, like a notary, somebody that you know out there, somebody that there's a business connection with who's willing to do that. I think now with COVID restrictions loosening a little bit and more travel going on, I'm seeing it be a little bit more common that if you hire a new employee at some point early on in their employment, they're going to be coming to your facility and you're going to have a chance to check the I-9 IDs. But within 3 days, that's really, really tricky. So I don't really have a clear answer for you on that one. And I think personally, it's kind of archaic because of the remote situation, but it is what it is. Some employers, yeah.
The 3 days, that's 3 business days, correct?
I believe so. I think so. I'm not 100% sure, but I think so.
Okay.
So E-Verify, if you are a federal contractor, you're already doing that. For most employers, it's optional, but it doesn't mean that you don't have to have the physical I-9 copies there. Even if you're doing even if you're doing E-Verify, you still need to have physical I-9 copies at the office. So this COVID exemption that I was talking about, right now, you're getting a pass due to COVID as far as that you need to physically verify the IDs. So because of COVID, because so many people have been remote, it's okay to not examine the actual copy. So you can do it like via Zoom or have copies sent. However, as soon as this exemption is lifted, and right now, and this is one of those exemptions that's been pushed, the deadline keeps getting pushed out and pushed out. Right now, it's October 31st. Within 3 days of the expiration of this COVID exemption, you're going to be expected to physically inspect the documents if you haven't already done so. So if you have any employees, I think a best practice would be if you have any employees who are remote, and if they're going to be on site or with any coworker who can verify I-9 IDs, okay? It can be a meeting of 2 people. It doesn't necessarily have to be you. Ask them to bring their IDs with them and have that person complete an I-9 form for them. Because at some point, you're going to have to do it. And you don't want to be under the gun as far as 3 days after October 31st, because they're probably not going to decide until very close to October 31st whether or not that's going to get extended. So your best practices for the files is some employers prefer to keep copies of the documents, and that's fine. But what you should, the best practice is you keep documents for either everybody or you keep the copies of the documents for nobody. And again, the reason being that a lot of these documents have photos on them, right? And that will disclose things like race. It could disclose national origin, particularly things like passports. So you don't want to create that perception that you're keeping copies for some, but not all, because these are documents that could potentially be used for a discriminatory purpose. Not that you're going to do that, but it's the perception that you have to be careful of. So I look at it as it's an all or nothing. If you have copies of IDs on a handful of employees, but not everybody, then just go through and pull out the copies of the IDs that are with the current I-9s and shred them so that you're keeping them for no one. And there's pros and cons on both sides to keeping the IDs. Some say, well, it makes sense because then if it's ever questioned whether or not the document was legitimate, here's a copy, looks legitimate, right? But on the other hand, you've got that all or nothing thing that can get you into trouble. So it's up to you. Just make sure that you're not putting your I-9s in your employee files. They should be maintained totally separately for a number of reasons. Number one, anything in an employment file really should only be anything that's made for an employment decision. And second of all, if you do get audited, you want to be able to hand over the separate I-9s. You don't want an auditor coming in from the USCIS and potentially having access to your employment files. So they should be kept separately. Retention is 1 year after termination or 3 years after the date of hire, whichever one is longer. And a system for file maintenance that I've tended to use is you make it a part of your terminated employee checklist to pull the I-9. You keep your active I-9s in one folder, your inactive I-9s in a separate folder. And I would always put the date that the I-9 could be destroyed on the top of the I-9. And then once a year, you go through the end of 2022, you should have a stack of I-9s that can be shredded at the end of 2022. And you just pull them out and stick them in the shredder. Job descriptions. Everybody wants to have them. Not a lot of people do. They are really, really helpful in a number of ways. You know, first of all, we talked about ADA compliance and your essential functions. And if you ever have somebody looking for an accommodation, the job description is invaluable because it's going to specifically list what your required skills and abilities are, what your essential functions are, and you can get really detailed with, well, these are the functions I can do, these are the functions that I can't do. It's helpful with things like disability, things like getting somebody back to work with workers' comp. You want to have a job description so that you can get back to light duty or full duty as soon as you possibly can, because you don't want to be paying them on workers' comp if you have some work for them to do. And you know, a best practice here is that it be discussed with the employee once a year. Sometimes it happens, sometimes it doesn't, but that's a good way to make sure that your job descriptions aren't becoming hopelessly outdated, is incorporate it into some sort of a performance appraisal process and have the employee reviewing that job description on a regular basis. So it's so that it's updated and it doesn't become obsolete. And remember that a job description can also be shared with a medical provider if you're trying to come up with a reasonable accommodation, or if you're trying to get somebody back to work from workers' comp. It's really helpful if the medical provider will often say, well, what does this person do? If you don't have a job description, they're going to be listening to the employee. And if that employee doesn't want to get back to work, that employee is going to think of a million things that they're required to do at work that they just can't do. And the medical provider is going to say, okay, you can't do that. Fine, you get to stay out. If you have a job description, it's a much more objective process. And they actually have a document to go by. So again, your best practices is to make sure that they stay updated. I like to see employees signing and returning a copy, and then also be given one to keep. That's just a nice practice. And again, it can be done in conjunction with some sort of performance appraisal process. And I think it's a good way too for an employee and a supervisor to have a dialogue and to be talking open and honestly about what their job entails and what it is that they're doing and where they might be falling short. I just think it opens up the door to a lot of good discussion. Which leads us to performance feedback. I often have employers coming to me and saying, well, what do you recommend? You know, should we be doing annual performance appraisals? How often should we be doing it? And, you know, it does kind of depend on your organization. If you have the important thing when you're looking at how you're providing your employees with feedback is that it be something that is done on an ongoing basis, and fairness, consistency, something that's kind of being that check that, hey, everybody is getting this feedback and everybody's being held to the same standard. And that's something that very often falls on you as an HR person, because we all know we have a lot of different variations in supervisors out there, and they have a lot of different standards. And it's really hard when you've got one group of employees that's working for somebody whose standards are up here and another group of employees working for somebody whose standards are considerably lower. And that's where you as HR come into play to promote some sort of consistency with what are the standards that your employees are being held to. And the documentation piece is really important. So whether you document on a formal basis once a year, that's always a minimum requirement that I like to see, some sort of performance appraisal being done annually, or whether you have more frequent check-ins. That's fine too. If you want to have monthly check-ins and have 3 or 4 sentences documenting the check-in, that's totally fine. That's preferable really to something that's done annually, as long as there is some sort of documentation to go back and look at. And the documentation is good to just refresh your supervisor's memory as far as, well, what did we discuss last time? And it also comes in handy if you've got somebody who isn't meeting performance standards. You want to see that what deficiencies have actually been discussed with the employee in the past. Your hiring practices, I think it goes without say that they should be non-discriminatory. Again, they should be ADA compliant. So let's go back to the job description a minute. I'm a big proponent of, at some point during a hiring practice, sharing the job description with the prospective employee, having them take a look at it, making sure that they're familiar with what it is that they're actually applying for and what's going to be expected of them. And also from an ADA standpoint, to give them the opportunity to say, I'm going to need an accommodation to do a few pieces of this job. And then you start that interactive discussion that we talked about earlier. What kind of an accommodation? And remember, the employee shouldn't necessarily be telling you what their disability is. They should be focusing, and you should always be focusing on what's the accommodation that's going to be required, as opposed to what is your disability, right? So that's kind of one of those questions that shouldn't be asked. You should be focusing on what can you do? What are you going to need help doing in order for you to do this essential function? You should be aware of local and national employment laws. And in a few minutes, we're going to be touching on a couple of Vermont employment laws that you need to be aware of. And I'm also a big proponent in documenting your decisions. Why did you hire this person? Why did you not hire this person? So that you've got something not only to refer back to, say that person reapplies for a job in another 6 months. Wait a minute, we already talked to this person. Why didn't we hire them last time? If you have a lot of applicants, it's easy to forget. But it's also good to have it documented because you want to show that you have objective job-related reasons why you are hiring a particular candidate and why you're not hiring another candidate, so that it doesn't come back to bite you that maybe you didn't hire this person because they had a disability and you didn't try to accommodate it. Your employment application, if you have one, I'm again a big proponent of documentation. So I like employment applications, particularly you probably have them if you have employees who wouldn't necessarily have a resume. But I kind of like to see an application for everybody, and there are a couple reasons for this. It allows you to ask the questions that you want the answer to. On a resume, resumes can be very deceiving. They can leave out important dates. They can say, well, I was employed here from 2020 to 2021. Well, was that 2 months or was it almost 2 years, right? You don't know. On a job application, you're generally going to say month and year that you started a job and that you ended a job. So you can start looking for those gaps. And I'd like to see the application filled out as opposed to just somebody saying, see resume. Because again, the application's also going to give you, usually there's a disclaimer at the end of an application that says everything that I've just disclosed to you is the truth. So in the event that you're checking references and you find that something that that person was not truthful, there's a very cut and dry reason not to hire that person. And usually the disclaimer also says, you can check my former employment, and it gives you permission to do that. Usually an application will say, can we contact this employer? Because the reason for that is most employees aren't going to want you to contact their current employer, and that's perfectly acceptable. So in Vermont, we have a couple of important pieces of legislation here. We have what's called the ban the box legislation, which basically means that you cannot ask about criminal history on a job application. If you have an old application and it's asking that, make sure that you redo it, because it can't be there. You can ask about criminal history during the interview process. So I wouldn't recommend it, but it could be your first question in an interview. That's okay. The idea is that it gives the applicant a chance to verbally explain what their criminal history might be. There's a very narrow exception to this, is if there is some sort of a federal or state law that prohibits you from hiring someone with a certain criminal background, then you can put it on an application. it's something that I would check with legal counsel on before you do that, just to make sure that you're in compliance. And we also have a salary history inquiry law. So you cannot ask candidates about how much money they had been making previously. You can say the job pays between $60,000 and $70,000 a year. Is that an acceptable range for you? That's totally fine. You can also ask them for their required salary. That's fine. This is where training of hiring managers comes into play, because hiring managers may not all be aware of the fact that they can't ask about the current salary. And you don't want them asking that in an interview, because it's a slippery slope, right? If you don't want to overpay somebody. Because if you think somebody's coming out of a nonprofit and, oh, they couldn't have been making a whole lot of money, so we probably don't have to pay them a lot. What were you making at your last job? Can't ask that. The rationale being a very simple one, it perpetuates lower salaries, particularly when it comes to women and minority candidates. So your best practices when you're selecting candidates, again, just make sure that your managers are making objective job decisions. Check references. I can't emphasize this enough. Even if you're just verifying dates of employment and position held, you'd be surprised at how people fudge their dates on job applications. So go back, check the references. And I'm also a proponent in, if somebody hands you a written reference from a previous job, that's great, but nobody's going to hand you a reference that isn't stellar. Go back and check other references. Make sure that you know the relationship, that it's somebody that the employee actually worked for, or maybe it's a former coworker, but take the time to make the phone call, because you'd be amazed at what you can tell when you're actually hearing somebody's voice inflection on the other end. They might be telling you good things, but you can kind of tell from their voice that, well, I don't know, may have been a little bit of an issue. I can't talk about it, right? You're going to get a lot of good information generally. If you have any further questions of an applicant, don't be shy about going back and asking them about it. Document those reasons for hiring and not hiring. And again, train your managers just to make sure that they're making objective decisions and that they're not inadvertently asking for information that they shouldn't be asking for. New hire paperwork is really pretty cut and dry. You have a lot of flexibility with what you want to do, but you are going to want to have them fill out a W-4, an I-9, usually direct deposit. Word of warning on direct deposit, you actually can't require direct deposit in Vermont. You can strongly recommend it, but the thought is that there are some people that for one reason or another can't have a bank account. So if somebody refuses direct deposit, you can't force it on them, just so that you know. If you have a handbook, and I strongly recommend that you do, have them sign off on the handbook acknowledgement. Your benefits notices can all be given out as part of the new hire process, and anything that you think is important to include about your company, by all means, include it in the onboarding. And an awful lot of employers are using some sort of online onboarding system. That's fine. That makes it really easy. You can just upload it. Your offer letter, again, it should be welcoming. It should talk about what of the employment are, your job title, your starting date, your salary. And just so that you know, if you're going to put an annual salary in there, that's one of those things that an employment attorney will say, well, that could be contractual. It could imply that even if this person only stays with you for 3 months, you could be obligated to pay them their entire annual salary. So it's best to state the salary in terms of per pay. This is what you're going to get per pay. Or if it's an hourly rate, it's a non-issue. And I know we have just hit 10 o'clock. If you don't mind, there's just a couple more minutes. If you need to go, I totally understand. So your employee handbook, absolutely should have an employee handbook. And here's why. It does outline your employment policies and your practices. And it sets the tone for what do you want that employer-employee relationship to look like? What are the expectations? What do we expect of you as an employee? And what can you expect of us as an employer? It also satisfies some of your dissemination requirements. We talked last week about your harassment, needing to disseminate your harassment policy to all new hires. If you have it in your handbook, you're covered. And some states, there are also, like New York has some dissemination requirements that can also be included in a handbook. And I like to see if you do have out-of-state employees and there are notice requirements that are different for them than there would be for your Vermont employees, you can always just have a separate addendum just for your New York employees. It does ensure that there's consistent treatment of all of your employees, hopefully. It also clarifies things like your time off. I will say that the number one place that all employees go to in the handbook is going to be your PTO or your vacation time. They all want to know how much time off they get. So take a look at that, make sure that it's really clear and make sure that it's what you want it to be. And, you know, a good handbook is going to sell you as an employer. If you're starting a new job, it's your first day and you're handed just a stack of policies that are just thrown together, you're probably not going to look at them. And it's not going to be well organized and you're not going to know where to find things. But if you're handed a handbook that has a nice table of contents, it flows from one right into the other, it's actually a useful document, your employees are going to be more impressed with you as an employer and they're going to be thinking, oh, okay, I'm welcome here. If it has that welcoming tone to it, right? It goes a long way when you have a new employee who takes a look at your handbook for the first time. So it's kind of a good selling point for you. And it can help you to win unemployment in legal claims. So, you know, for example, if you've got an employee who very blatantly violated one of your policies and they're going for unemployment, say for, and I'll use this as an example, somebody who has abandoned their job, right? They just stopped showing up for work or ghosted you. And now all of a sudden they're applying for unemployment. If you have something in your handbook that says, if we don't hear from you for 3 straight days or 2 straight days, this is considered a voluntary resignation. And voluntary resignation would preclude them from collecting unemployment. So it can be really helpful. Your best practices with a handbook is to have one and then to actually use it and have your managers use it regularly. Make sure that it gets updated because things change, circumstances change, your practices change. You kind of have to strike that balance in a handbook with, you know, you want to be informative, you want to give good information to your employees, but you don't want it to read like a rule book. And I know sometimes employment attorneys, they will give you a handbook that reads a little more like a rule book. They don't really soften the edges too much. That's where you can come in. However, I do absolutely recommend that whatever handbook you put in place, that you ultimately have an attorney reviewed, because they're going to be on the lookout for language that could potentially come back to hurt you. It could be contractual, something that could get, they know their case law, they know what wording can potentially get you into trouble. I would also recommend putting it out there online because nobody likes paper anymore. Nobody wants a book. They want to be able to just look at it and have it be a searchable document so that they can find what it is that they want to find right away. And that acknowledgement form is really important. So have that as part of your onboarding process, that all of your employees will sign that acknowledgement form. And that form would say that, and then if you have significantly altered your handbook in any way, review it with your employees and have them sign off on another acknowledgement. So do we have any questions?
No.
Okay. And I will just wrap it up with a quote. Sir Richard Branson is apparently a very wealthy, very successful British businessman. And he said, train people well enough so they can leave, treat them well enough so they don't want to. So I think that sums up a lot of what we in HR do. We want our people to be marketable, but we don't want them to leave. We want them to like working here. Kind of a tricky balance, but I think it's something good to aspire to. So no other questions? Feel free to unmute if you've got questions on any of this. No? Okay, I think we're all right. There's my contact info. So for anyone that I have said, reach out to me afterwards to go over this. That's where you can find me. And again, your account execs are always there to help you as well. And if they need to pull me into it, we all work together as a team and we'd be happy to help you out. There's also going to be a survey that I'm going to be sending out, and I hope that everybody takes a few minutes, and it will only be a few minutes to fill it out because that helps me to plan going forward. I'm going to ask you for suggestions for other webinars. That's really helpful for me. And I'm also trying to get a handle on whether or not people prefer the webinar format or whether they would prefer some sort of in-person training. So please take a couple of minutes to fill that out. I'd really appreciate it. Thanks so much, everybody, and have a great rest of your day.